Okay, parole evidence. Interpretation versus parole evidence. They are not the same thing. Helfand repeated. They are not the same thing. Please do not put them together. They are not the same thing. So interpretation is what a contract means. So what is on the face of the contract and what does it mean? So like why we put something on the paper. So what on this paper does it mean? Parole evidence is saying what is part of the contract. So if it's not on this page, should we allow it in? This isn't a contract, this is my outline. I have another point, but I think that's wrong. So we're gonna just circle it. So interpretation is, I have the page of the contract and I'm not sure I understand what this means. And parole evidence is, no, we've got other stuff going on. Is it valid to be part of this agreement or not? And so the first thing is you're gonna ask is, so the contract that you have, is the agreement integrated? And if it is the agreement completely or partially integrated? So integration, restatement 209, integrated agreements. An integrated agreement is a writing or writings constituting a final expression of one or more terms in an agreement. Completely and partially integrated agreements, 210. A completely integrated agreement is an integrated agreement adopted by the parties as a complete and exclusive statement of the terms of the agreement. So it's final, it's got everything in it, anything else not part of the agreement. A partially integrated agreement is an integrated agreement other than a completely integrated agreement. So if it's not like a final, has everything included, then it's partial. Whether an agreement is completely or partially integrated is to be determined by the court as a question preliminary to determination of a question of interpretation or to application of the parole evidence rule. So first, is it integrated? Is it partially or completely integrated? In other words, do this first, which probably you should have done the videos for, doesn't matter. Restatement 213, effect of integrated agreement on prior agreements. And this is the parole evidence rule. A binding integrated agreement discharges prior agreements to the extent that it is inconsistent with them. So if previous agreements aren't consistent with the new agreement, they fall away. A binding, completely integrated agreement discharges prior agreements to the extent that they are within its scope. Put differently, if a contract is partially integrated, then it cannot be contradicted by extrinsic evidence, but it's not exclusive. So other agreements can supplement, but they cannot contradict. So there you go. It may, however, be supplemented by additional consistent terms. If a contract, though, is fully integrated, then not only may it not be contradicted, but it also may not be supplemented. So fully integrated, no to both. No contradiction, no supplementation. Partially integrated, you can't contradict, but you can supplement with things that aren't in the agreement with parole evidence. So this is Thompson v. Libby, case to by logs. I put laws, hello. Okay, so they were supposed to buy logs, and they said there was a verbal agreement for a warranty, and they looked at the contract, and they considered the contract fully integrated. So the contract had all material terms, so it was ruled fully integrated, which means no additions could be brought forth. The rationale for the parole evidence rule, they call this the uncertain testimony of a slippery memory. I don't like this because he specifically told us to keep them separate. But What about using parole evidence to determine the level of integration? So then we have two different camps on this. Thompson and the Thompson camp, we're going to call it the Thompson camp. They look at the four corners of the contract, and to use parole evidence to determine the level of integration would allow parole evidence in through the back door. So you're most likely not going to be able to use it unless maybe the contract nods to other things like this should be found from market value at the time of 2 years from now or whatever. But then you have the Corbin restatement, and they say look at the evidence to decide the level of integration. So determine the level of integration in light of all surrounding circumstances. How can an agreement prove its own level of integration? So Thompson says, nope, the contract has to show it's only partially integrated, and if it doesn't show, you can't use parole evidence. Corbin says, it's not going to show that it's not fully integrated because we don't know what we don't know. You've got to use the evidence around it. Parole evidence can be used to interpret the contract, just not to add to or vary the contract. So parole evidence of extrinsic facts and circumstances would, if necessary, be admissible, as it always is, to apply the contract to its subject matter and in order to provide a more perfect understanding of the language. So kind of like the chicken case, like there were all of these experts coming in to say how you talk about chicken, and that evidence can be used. But in such a case, such evidence is used not to contradict or vary the written agreement instrument, but to aid, uphold, and enforce it as it stands. So parole evidence of extra agreements can only be for a partially integrated contract where it does not contradict any material terms, but it supplements. And for that, there's a question. Could the claim of agreement for a warranty be considered a collateral agreement? And the answer is no. The common sense of men would say, and correctly so, this is either Posner, it sounds like Posner, or Learned Hand, because they're very wordy, that when on a sale of personal property, a warranty is given, it is one of the terms of the sale and not a separate and independent contract. Excuse me, I gotta have some coffee. Merger clauses, entire agreement. This document so a merger clause would say, this document constitutes the entire agreement of the parties, and there are no representations, warranties, or agreements other than those contained in this document. Then the contract will say, I am fully integrated. But just because it doesn't have that doesn't mean it's not fully integrated, so that's why it's hard from the four corners. Exceptions to parole evidence rule. To determine meaning of agreement, that's not really an exception because it's evidence too. Anyway, exceptions. Okay, agreements made after the execution of a written contract. So obviously if you made an agreement after, it's not going to be in the contract. So illegality, fraud, duress, mistake, lack of consideration, or other invalidating cause. We're going to talk a little more about that because that gets a little messier. And collateral agreement, which is a second agreement that will be included if it is an independent and not inconsistent of the original agreement. So we just, like, warranties don't work because warranties would be separate, but a collateral agreement would be kind of like a parallel agreement, but it can't be inconsistent. I'm going to ask about something. Okay. And so the hypo for this is John sells and delivers a hotel to Mike. Later, John takes possession of the hotel furniture and Mike sues to recover it. Mike claims that prior to the sale, John stated that the hotel sale will include all the furniture. John responds by pulling out the written contract, which says this sale shall only include the hotel and the real estate of the property as described below. The contract is signed by both parties. On this basis, John argues that the furniture was not included in the sale. So what is the level of integration? Well, this sale shall only include, it's not really a merger clause fully. Is it a partial? Does the oral agreement supplement or contradict? So this is where you could argue, hey, John said this sale shall only include the hotel and the real estate, so it's obviously fully integrated, and the oral agreement would contradict it. But the other argument is, we'd look at what is the trade usage for hotel? Is it common trade that when you sell a hotel, it includes like the hotel and everything in it? Because like a hotel has rooms that need to be furnished. In the sale of a home, obviously that's not common usage, so no one would think that. But off the top of my head, I don't know if when you sell a hotel, it usually comes furnished with everything. And if that is common, then it would be a supplement, and it would not contradict because hotel furnished could be common. So that's kind of you could argue it either way. And then if the oral agreement is barred by the parole evidence rule, can the oral agreement be used to interpret the terms of the contract? And that's kind of what I was just doing, because if it is a separate agreement, it probably cannot come in as parole evidence as to a separate agreement, because it does say just the hotel. It will have to come in on interpretations of the terms. And then we have Sherrod, Inc. v. Morrison. Oral misrepresentations about a construction job were not allowed in where contract was found integrated. So generally there is a fraud exception to the parole evidence rule. So if there was fraud, you can make an assertion of that and show evidence of the fraud. However, if the fraud directly relates to the subject of the contract, some courts will apply the parole evidence rule and bar the evidence. So if the contract is fully integrated, parole evidence says it can't come in, which is what Sherrod said. But some courts will not apply the parole evidence rule because basically that they'll say, well, if it was fraud, then we're not going to believe that it was fully integrated because it was fully integrated fraudulently, like specifically to make the parole evidence rule uphold their fraud. And we don't want to do that. So, but that was what the dissent said. The majority said it's fully integrated. We're not going to let you bring in your allegations of fraud. That can only be shown by the evidence you have. Restatement 214D, agreements and negotiations prior to or contemporaneous with the adoption of a writing are admissible in evidence to establish illegality, fraud, duress, mistake, lack of consideration, or other invalidating clauses. So the restatement is what the dissent used in Sherrod. Promissory estoppel versus parole evidence rule. Majority of courts will not allow claims of promissory estoppel in order to avoid the parole evidence rule, but there are a handful of cases that have allowed parties to proceed with claims of promissory estoppel notwithstanding the parole evidence rule. So outside of our contract, I relied on a promise, and you need to pay me for that reliance. It's like, why would you have a promise when you have a contract? Why wouldn't you just do a contract? So that's why courts are like, and use of parole evidence. So what we already said, Williston is a restrictive view, and it's to supplement a partially integrated contract or to interpret an ambiguous contract, and you can only use, you're using the four corners of the contract to start from. And then you have Corbin to determine the level of integration, to supplement a partially integrated contract, to determine whether a contract term is ambiguous, or to interpret an ambiguous contract. So Corbin is using parole evidence to also decide if it's ambiguous, interpret it if it's ambiguous. Williston says, no, we got to find ambiguity first, which is, we said that in the interpretation, that Williston is like, you're going to figure out the level of integration and the ambiguity before you can bring in any evidence. And Corbin is like, no, bring it in, tell us what you feel. Yeah. Okay, so that's parole evidence.